are on the record, Your Honor.
Thank you. In the matter of Michael Turner versus Ingrid Casillas, case D15521-527C, please state your appearances for the record.
Jack Fleeman, bar number 10584, on behalf of Michael Turner, who is also present via Blue Jean Shirt.
Great, thank you.
Sorry, Amy Poirier, bar number 9596, on behalf of Ms. Casillas, who is also present via Blue Jeans.
Okay, thank you. Welcome. So it's my understanding we're here on Dad's emergency motion to temporarily modify custody and set supervised visitation for Mom and Mom's opposition. Mr. Fleeman, would you like to bring me up to speed on what's been going on? It seems like you filed this motion quite a while ago.
Sure. We tried to get the motion on an OST. I think this may be an OST setting, but it's pretty much the quickest the court could do, I believe. As a bit of background, I think it's important for the court to know what's happened between these parties and this child. The child is Mariella. She's 5 years of age. A couple of years ago, Mom filed a frivolous motion to relocate, which we eventually settled that issue. At the same time, Mom made a false domestic violence claim against Dad. She pursued that all the way through the criminal court, and Dad was charged with a felony despite no evidence of any domestic violence. The district court judge in the criminal case acquitted Dad and found that Mom was not a credible witness and that there was no evidence of domestic violence at all. In addition to that, Mom made false claims that Dad was sexually abusing the child, that Dad was holding guns to the child's head. She made at least half a dozen CPS reports, all of them unsubstantiated. Mom has repeatedly taken the child to the doctors for alleged constipation and asthma. She didn't provide any notice to Dad regarding those visits to doctors. All of the medical records show that the findings from the doctors and the diagnoses are based solely on what Mom has told them. Mom is overdosing the child on Miralax, a laxative, just before Dad's time, which results in the child having uncontrollable bowel movements for the first couple of days during each of Dad's visitations. And she repeatedly calls the police and alleges that Dad has kidnapped the child, even though she knows where the child is, and Dad has not kidnapped the child, and it's during his time. This came to the head again this year when Mom withheld the child shortly after we made a stipulation in the last case to go to joint physical custody. Actually, Mom wanted to call it primary, so we still call it primary even though they have pretty much equal time, and Dad actually has a little bit more time. But Mom technically has a label of primary still. But this year she made 3 or 4 more false claims of sexual assault, saying that Dad had sexually assaulted the child. She had the child undergo at least 2 sexual hits. She had the child forensically interviewed by Metro, and we had a Metro detective at the last hearing. And the Metro detective stated on the record there was 0 evidence that the child had been sexually assaulted, that Mom just kept repeating her claims. And when they dismissed Mom's claim, she'd come back the next day and refile again with the exact same claim. At that hearing, Judge Moss, because of the Miralax issue and the doctor issue, she granted Dad sole decision-making authority on medical decisions. But that's where we stood when we left the last hearing. Since that hearing, Mom again called the police alleging Dad kidnapped the child when he took the child to his siblings' house out of state. We're going to have text messages where Dad notified Mom where he was going. Mom called the police in Simi Valley and had them show up at Dad's brother's house claiming kidnapping. There are difficulties at every single exchange that these parties have on Fridays. There's several occasions where Mom has refused to turn over the child. There's one occasion where Dad was detained in the police department parking lot by the police because Mom said that he had sexually assaulted the child and that he had kidnapped the child. I've produced as exhibits a few of these videos. But also since that time, Dad took the child to the doctor. It's one of the first times he's been able to go to a doctor with the child. And the doctor said, well, the doctor basically said, I don't have any evidence of the asthma or the constipation other than what Mom's told me, so I'm going to discontinue all the medications. He then said Mom is not to take the child, give the child any of those medications or any medications, that she has to bring the child back to the doctor. And this is a doctor that Mom had been taking the child to, so it's not some new doctor. Subsequent to that, the doctor in the notes says, I told Mom these instructions. She came into my office right after the child left, and I gave her detailed instructions. In less than a week, mom had taken the child to the emergency room for alleged constipation. She had the child re-prescribed with Miralax, which she was told not to do. She's put the child back on Miralax. The overdosing continues. She will not follow court orders. She continues to say that dad is sexually assaulting the child and kidnapping the child. We have a child custody evaluation. I think the report is due February 1st. But in the meantime, I mean, this child is just going through the repeated nonsense that's causing her harm. I don't know if the court is willing to watch the part of the video today. I've submitted it as an exhibit, so I don't know if the court's already reviewed it. But I've provided 3 videos of 3 separate exchanges. They all occur in the police department parking lot. In the video that I'm referring to, grandmother, who goes and gets the child out of the car, tries to get the child out of the car. Mom shuts the door so that she can't get in. Mom then walks away with the child. Eventually, mom gives the child to grandma, and grandma starts walking towards dad's car. Mom then runs up and starts talking in the child's ear, and the child starts screaming and crying and freaking out. So the child is crying, which is mom's allegation, is that the child doesn't want to go with dad because she's crying. But in the video, you can clearly see the child is fine until mom runs back up to the child and grabs her and picks her up and says something in her ear. This goes on at every child exchange, every week. And the child needs some sort of protection. I know we have an evidentiary hearing set. I know there's a child custody evaluation, but these are the facts. Mom will not listen to any court orders, and she continues to put the child in the middle and expose the child to things like sexual assault kits and CPS interviews and forensic interviews by Metro detectives. It just will not stop, Your Honor. And so we're asking for the court to intervene and order her, pending the evidentiary hearing, to supervise visits in a public place twice a week only, not to contact the child's doctors. Dad can provide her with the information. There's also schooling issues. Those are a little bit less important in my mind. But at the last hearing, mom said the child had already been enrolled in school. It was after the start of school. We later found out she hadn't enrolled her yet. She hadn't gone to school. There's issues with whether or not the child's even doing the schooling during mom's time. So those are all a little bit less important, Your Honor. Would the court be inclined to watch that part of the video, Your Honor?
I've not seen it. I don't. I'll have to find out where that is, how I can access that. I'm not sure about that, but I am. You have it. Are you able to play it right here during the hearing, kind of thing?
Can you see the screen?
Yes. Oh, okay. And where is this located?
So this is at a Metro substation.
Okay.
This is grandmother, the child, and mom. Mom has taken the child out of the vehicle and walked away. Dad is filming from his car. And you'll see in the video that the child goes with grandma, and then mom, and the child is fine, not crying or anything. And then mom comes up to the child and grabs her and starts whispering into her ear, and the child starts freaking out. You'll also see later in the video, it's only like a minute long, that mom brought some unknown third party who then runs up at the end of the video where the child can hear and claims that dad is sexually assaulting the child. This is what happens at the exchanges. I'll just let it play.
Is there audio?
There will be. There is audio. You can hear wind noise.
I don't hear anything. I don't hear anything. Should I be?
Could you not hear anything, Your Honor?
I couldn't.
I don't know why you can't hear it.
Neither.
I'll represent to the court that there's not a lot of audio that you can hear until they get close to the vehicle. The woman at the very end is one of mom's friends, and she says, "Why you keep molesting her? Why are you molesting her? We know." That's what the woman says at the end. But there's not really any verbal audio. There's just wind noise, and that's essentially it until they get close to the vehicle. But
Okay.
those exhibits were provided to the department via a share link because
Okay.
they're too big to produce otherwise, and they were produced to council as well.
Okay, thank you. Anything further, Mr. Fleeman?
No, Your Honor.
Okay, Ms. Pare?
Thank you, Your Honor. I'd like to correct some of the representations that Mr. Fleeman made. I'm going to start with the doctor. He referred to alleged. We sent over, and in fact, regarding the alleged constipation, Ms. Casillas took the medical that she received from an emergency room visit that she took Mariella to regarding constipation. This was after Mr. Turner took Mariella to the doctor, and the doctor visit that Mr. Turner was, or that Mr. Fleeman was saying that Mariella was not constipated at. She took her to the emergency room. This was October 22nd to the 23rd to be seen because Mariella was constipated. She had a CT scan and was found to have a moderate to high obstruction in her bowels with feces. We provided those reports to Mr. Turner. Ms. Casillas provided those reports, and Mr. Fleeman disclosed those yesterday, actually the reports, and it shows the CT scan results in those. And so the doctor there prescribed Miralax, and not because of anything that she said, because of the imaging results. As far as the child exchanges, if you had shown the whole video, it shows that grandma goes over to the child and the child is not wanting to go with grandma. We think that the conflict could be minimized if Mr. Turner was to go over and have the child go with him. As far as grades and school, the daughter just got her report card for the first semester. She got a B in reading, a B in language, a B in math, an A in science, an A in social studies, an A in PE, and an A in health. I don't know how that equates to her not going to school.
If you produce that to Mr. Fleeman?
Ms. Casillas gave that report card, she just got it, to Mr. Turner, and so we will produce that to opposing counsel. Instructed her, she had just gotten it, I instructed her to give it to Dad immediately. Once she sends it to me, I will produce that. Yes, absolutely.
Thank you.
As far as in primary physical custody, or that being called that, as per the last court order, it states that they have temporary joint physical custody, so I don't know why that designation was changed. We put that and cited that in our motion.
I'm sorry, can you repeat that, Ms. Pare? What did you just say?
As per, it was in the last court order, they have changed the designation of their physical timeshare to temporary joint physical custody. So that designation has been changed. It's no longer the primary physical that is in the court order. Just correcting that for the record, because he does have Friday at 5:30 until Tuesday at 7:30 a.m. As far as the out-of-state travel, he did not give her an itinerary. So although Mr. Fleeman says that he was with an uncle, she didn't know where in California. She called the police department here purely because she didn't know how to find her. She didn't want to report kidnapping or anything like that. She didn't know how to find her. They said call over into California. She did. She had tried calling Mr. Turner as per the court order because he is supposed to allow her to have contact with Mariella. If a party goes out of town, they're supposed to allow contact with the every day while that party's out of town. He never allowed that. He didn't respond to her whatsoever. So that's why she was concerned. It wasn't a report of kidnapping. It was, I want to know where he's at. I want to have contact with my daughter. She didn't know how else to find her daughter. And that's what the police told her to do. It wasn't anything nefarious. It wasn't anything to get him in trouble. She has been in compliance with the medical appointments. He was given sole legal custody over medical decisions, but she is allowed to go to the appointments. She is allowed medical information. So she did go to the doctor. She did try to get reports. He doesn't share medical information with her. He rarely responds to her on App Close. She'll send him messages, and I got the text messages from her last night, where she, in fact, in January, just recently, will send him message after message. How is my princess? How is my princess? How is my princess? He will send her a response of an okay sign, the emoji. That's it. Nothing else. Sometimes he doesn't even respond. For example, it's one thing that I'll need to address. She sent him her school schedule for this semester saying, hey, school time has changed to 7:45 in the morning. Are you okay? Because now on Tuesday morning, the school schedule is at 7, the drop-off is 7:30. Are you okay with changing it by a couple of minutes so I can get her home and on her Zoom? No response. This is a common thing, no response by app. And I have the app post messages, like I said, I got from her to disclose. This is common. He doesn't share with her the information. It leads into as well what Mr. Fleeman was saying, you know, there's this issue of her not going to school. Mr. Turner has one day of school, and how he would think that there's no participation is concerning. Regarding the previous result or the previous allegations was dealt with in the September hearing. There is an extensive court order that was filed in November. Regarding all of that, there have been no further allegations. She has done nothing further about that. There have been no further allegations regarding domestic violence. There has been nothing else that has been addressed. Dr. Bergquist is doing a full child custody evaluation. This motion right now is in as far as I know, there have been no additional child exchanges other than those when the emergency motion has been won. Things are going smoothly right now. There is, in court's indulgence, I think that is everything that he has addressed. I think this is, the parties are high conflict, that we know. They were ordered in the November hearing to attend a high conflict class, as far as I know that. And I still think that's very appropriate for these parties. Some, like I said, some of this can be minimized by grandma not doing the exchanges, if that's possible. But a lot of what Mr. Fleeman said has been dealt with or is refuted by the actual messages that we have.
Okay, Mr. Fleeman?
Yes. I've been a part of this case throughout the years. Mom has had probably 6 to 8 attorneys. They all get off the case at some point when things go south on her side. As far as the medical records, counsel is representing that they gave medication based on an x-ray. First of all, the child shouldn't have been taken to the ER. The child should have been taken back to the same doctor, which is what that doctor required. The doctor did say if it's after hours, you could take the child to the ER. If the child had not taken a bowel movement, which is what mom says in the records, for 7 straight days, mom should have taken the child to the doctor. Instead, she waited until after hours and took the child to the ER. She told them that the child had not taken a bowel movement in 7 days. That's absolutely false. The child goes to the bathroom when she's with dad. The child has explosive diarrhea and uncontrollable bowel movements during her first couple of days with dad because of mom's overloading on Miralax. There was an obstruction in terms of the amount of bowels or the amount of stool in her bowels on the x-ray, but it doesn't say that there was a complete obstruction. In fact, it says that there wasn't in the x-ray, and who knows what's going on during mom's time. The point is, this was less than a week, or right around a week after the child saw the doctor, and the doctor told mom, do not take the child to the doctor. Take her back to me if you have an issue. And of course, she went around that because that doctor was no longer going to buy what she was saying. With regard to grandma being the person who does the exchanges, mom has levied domestic violence allegations against dad, prosecuted him with felony criminal charges, claims he sexually assaulted the child. She required that dad have supervised visitation in this case twice in the past. And who did she pick to do the supervision? It was grandma. She gets along with grandma. So to now come today and say, well, if it wasn't grandma and it was dad, this is the person she says holds a gun to the child's head and everything else. So it's clearly, I mean, it's ridiculous for her to come in here today and say, well, if it wasn't grandma. No, grandma is who she wanted to put in the middle last time. And so to come here today, that's just an excuse. I can play the whole video, and the court has a copy of it via the share link that we sent to Chambers. The video shows grandma trying to get the child out of the car. Mom exits from her side of the car, walks around, and shuts the door so the child can't get out. The child's not screaming or crying or anything like that until mom goes at the very end, grabs her back, and starts whispering into her ear. That's on the video, the whole video. Dad doesn't share medical records. I have copies of dad sending mom the copies of the medical records. It's just a last-ditch effort. And what mom doesn't address, and counsel was right, since we filed the emergency motion, I don't know that there's been any issues with the exchanges. And that's because we have an emergency motion on calendar. We have 3 videos of the exchanges before that, including mom calling the cops and having dad detained, alleging sexual abuse and kidnapping. Dad told mom where he was when they went to California. Mom says she needs a day-by-day itinerary. It was on a weekend during his time. He was at his sibling's house. He doesn't need to give her a daily, we're going to eat breakfast. That's what she wants. And counsel's also right. She constantly sends him text messages. How's my princess? How's my princess? During his time. He doesn't engage with her because it has cost him dearly in the past anytime he's tried. So yeah, these parties, when it's his time, it's his time. She gets to talk to the child every once in a while, but she can't continue sending messages, how's my princess, how's my princess, which is what she does, and which is what I haven't seen the app close messages that counsel's talking about. I don't think they've been produced. The temporary joint physical custody, that's correct. What I was referring to when I said that mom was granted primary is not December 2020, but December 2019, when we resolved the relocation issue. Part of the agreement was that mom would still be called primary. When we came back in September or October of this past year, the court noted that it was pretty much a joint physical, and based on what was going on, the court, under the best interest of the child, is allowed to make a temporary order, and that's what the court did. They said temporarily joint physical, sole medical decision-making authority to dad, sole educational decision-making authority to mom. Counsel, points out the educational issues and the schooling issues, and I mentioned that that's a minor issue compared to the others, and I think it is. But it's not that dad can't know what's going on with the child and he has no idea that the child's not participating. He has the ability to see what's going on with the child. The child's in kindergarten. So A's and B's, that's not the issue. The issue is the child actually enrolled in school or going to school? The child's going to get A's and B's. The child's in kindergarten. It's not going to be something different. Again, that's a minor issue compared to the allegations of sexual assault and holding guns to child's head and all these things that mom has done. And it has not stopped. It continues, and that's why mom keeps calling the police to the exchanges, and dad has been detained at least one time since the last hearing in front of the child. The child has witnessed this. There's a video that I produced, which is one of the 3, where the child gets out of the vehicle and is crying, don't take my daddy, don't take my daddy, because the police officer's there and dad's standing in front of the police car. And the police officer tells dad, no, you can't leave. There's no reason for that, but it continues. It's continued since she made the domestic violence allegations years ago, maybe 2 or 3 years ago. That criminal case, it needs to end, and mom does not understand anything in terms of a court order. She will not follow it. And so the only thing we can think of to do until the custody evaluation is in is ask that her visitation be supervised so that she can't overdose the child during her time, so that she can't poison the child against dad and tell the child that dad has so many guns that he's going to hurt her, which is what we believe she's doing.
Okay, Ms. Pere, what's happening during that video exchange? Why did the child get so agitated? It looked like it was a little bit disturbing. What was going on there? Why did the child get all upset? Why is she holding the child? The child's 5 years old.
If that is the video, that there are two videos that were produced. At the beginning of the video, once the grandmother walks over and the door is open, the child begins immediately screaming when she sees the video. She's 5 years old. She wants to be with both parents, and Ms. Casillas certainly, facilitates that, time with her father, but she starts screaming and, saying, I don't want to go. I want to be with my mom. She's 5. That's what kids do. They want to be with their mom. Then they go to their dad and they want to be with their dad. She doesn't want to go with her grandmother. She wants to be with Ms. Casillas. The court only saw a part of the video, and taken out of context, it doesn't make sense with the entire thing. That's just a portion at the end. If the court saw that video was a couple minutes long and Mr. Fleeman started it about I want to say I saw like maybe 2 minutes into it. When it starts,
I'll play it. So we have
in the driver's seat, and then Ella is sitting in the back of the car, and then Grandma walks, and then Mariella starts crying and kicking her legs and just crying, saying, "No, I don't want to go. I don't want to go. I don't want to go." And it goes on from there. I can't.
Okay.
Remember.
Well, I don't think that I need to see it again at this point, but it seems to me like the child is reacting to, the circumstances and the high conflict between the parents. Mm-hmm. Of course, this is very distressful for the child every time that this has to happen. I just have to encourage the parents to just be as low key about these exchanges as absolutely possible and just say, okay, we're going to go see mommy. Okay, now it's time to go see daddy. Have a good time, baby. Love you. And I mean, I don't know why all of this drama has to take place. Mr. Fleeman, do you have a position about why? I mean, I understand what you said about why dad would not want to have to come in direct contact with mom because of all of her allegations against him, so that it would seem easier that his mom is able to go and make those exchanges. But what if they were to reverse? What if if he still wants to have a witness there, I can understand that to protect him. I mean, what if mom, the paternal grandmother, were to stay in the car and he walks up and gets the kid? Hi, baby, ready to go? Let's go. Turn around, grab her suitcase, whatever, turn around, walk, get in the car. Why would that not work?
Yeah, I don't think that's going to be a problem, Your Honor. But honestly, I mean, the other videos, I hope that the court is able to watch the videos, because the other one, he actually has the child in his car already. Mom stands in front of his vehicle filming, so he can't leave the parking lot. And grandma has to kind of block her so that he can move away. And I can play that full video. That child is in the car. Mom shuts the door on the child. The court can see the child is not crying. The child is being carried. The child's walking away with grandmother, not crying, until mom approaches the child. We have 3 videos of exchanges, and none of them show what counsel is represented here.
Okay. Well, I'm not making any findings about what's going on in the videos, but because we'll definitely get to that if we end up having to go through the full evidentiary hearing. But it is disturbing. It just seems to me that that the child could be on her feet. I mean, she's 5 years old. Mom doesn't need to be holding on to her like she's a little baby. Okay, let's give her some autonomy. Let's give her some stability, and a little bit of confidence. And let the child, walk and take the hand of their parents and go from one to the other. I mean, like grown-ups.
Right. And my client doesn't have a problem being the one walking over and getting the child, and grandma can stay in the car. I don't think that matters at all. I mean, my client's going to continue to film because of all the allegations that have happened over the year. The exchanges happen at a police substation too, because mom wants it that way. So there's no risk of.
Okay, well, let's do that. And then as far as the videoing, I just don't want the child to be aware that there's always a video camera going all the time. I mean, can we be a little bit more clandestine with these videos if we feel like we have to video one another until we can hopefully maybe build a little bit of trust? I just don't like the idea of, you standing there holding the video like this in front of the child. I mean, the child's only 5, but she's, putting all of this together. And I just want these exchanges to be much more seamless and less stressful and for the child, because you're right, counsel. It is a high conflict case. I am happy to know that the parties are communicating with the app close. I do want the school records, medical records, everything regarding the child should be exchanged. I mean, there's no proprietary interest in this child, right? Neither one of you own this child. You share responsibility for raising this child. So I want a free and open exchange of information. I'm pleased to know that we're going to have this psychological evaluation. Has mom already had her appointment with Dr. Bergquist?
Yes, it's my understanding that both parents have been meeting with Dr. Bergquist. I know that mom has, and Dr. Bergquist has been getting records from both parents.
Okay, good. All right. So I'm not prepared to grant any of the relief that you've requested. Either party has requested today, but I do feel like the hearing was helpful. It kind of lays a little bit of a foundation on where this case is going, because I'll be the judge when it's time for the evidentiary hearing, which we already have calendar, correct?
Yes, I looked though this morning and it showed that it was on calendar, but it shows as being vacated. So I did want to ask whether that is going to be placed back on calendar on the same dates, or what is
okay. That's a great question. There, of course, has been a lot of confusion with the reallocation of cases, from department to department. We're getting it all worked out and ironed out. I know how frustrating it is from your end. I'm learning how frustrating it is from this end. So yeah, Madam Clerk, can you let me know what dates do we have on calendar that are forthcoming?
Your Honor, the only upcoming dates in this matter is for February 17th, 2021. It's a status check regarding the evidentiary hearing, as the evidentiary hearing set for June 4th, 2021 has been vacated due to the case reassignment, Your Honor.
Okay, so does that date work for y'all? Because it's probably open on my calendar. Do you want that date back for the evidentiary hearing? Counsel?
I would, Your Honor. Well, I have it calendared already as that, so.
Me too.
Okay, so all right, so let's go ahead and reinstate that date, Madam Clerk, for the evidentiary hearing.
Yes, Your Honor.
And do we need a calendar call? I like calendar calls, but on the other hand, I hate wasting money when they're not fruitful. What do you think, counsel?
I like a calendar call.
Okay, very good. Let's do that then. We'll have a calendar.
Yeah,
Sorry,
I generally
Freeman?
think the counter calls are fruitful to see if the parties are ready to go forward or if it's settled. I don't see this settling at this point because we settled about a year ago. And
Okay. All right, so let's go ahead and have a 1-week calendar call.
Yes, Your Honor. For clarification, Your Honor, June 4th is a Friday. I have that as chambers. Would you like me to add a trial setting for Friday, June 4th, Your Honor?
This is going to be a full day trial. Is that correct?
Yes.
that's right.
Yes. Okay.
Yes.
I'm thinking, do we have
Your
a full day setting like on a Thursday?
Yes, Your Honor. We do have available June 3rd, that is Thursday, for a full day setting beginning at 9 a.m., Your Honor.
Would that be okay, counsel?
That's perfect.
The trial before was set for June 3rd and 4th. It was day 1 of 2. already, so it was already partially set for June 3rd.
Okay. So can we just do a full day on the 3rd then? Would that be all right?
Yeah, I think it was set for 2 full days, but we may be able to get it done. Yeah, I think that was Judge Moss. She tended to give a little more time than might be necessary, so I think we'll be good with 1 day.
Okay, very good. Thank you, counsel. So June 3rd for a full day at 9 a.m. That'll be the evidentiary hearing. And then we'll do a calendar call 1 week prior, the prior Thursday.
1 week, Your Honor, prior is going to be for May 27th at 9 a.m.
Okay. And the court will issue that trial order regarding the pretrial memos and such. Let's see, what was the other thing that I had on my mind I wanted to take care of? Was there anything else, counsel, that we need? I don't know that we need I would like just a little brief order. Mr. Fleeman, would you prepare an order and run it past Ms. Perret?
Sure, Your Honor.
Okay. I really want to see some improvement in the interaction and communication of these parties. If either party is taking the child out of the jurisdiction, out of the state, you need to provide some notice and just an itinerary. Neither party has to inform the other party about what time they're going to wake up and when they're going to brush their teeth and where they're going to go eat breakfast and what they're going to do. We don't have to have that. Just a general, we're going to be in San Bernardino we're leaving Las Vegas at 3 p.m. on Friday. We'll be back Sunday at, around 5 p.m. This is the phone number where you can reach us. We're going to be staying at such and such a hotel. Here's the address. Boom. That's it. That's all that has to happen. We don't have to have frequent all-day reassurances from the child that the child's alive and breathing and what the child is doing continuously. It would be nice if these parties could reach a level where dad could be more comfortable to say, we had a great day. We got to go to Disneyland. She had a wonderful time. You can ask her about it. And then maybe, they could have a conversation about it. But you don't need to have repeated check-ins all day long about what the child's doing. When the child is with dad, the child gets to do things with dad and enjoy his time with dad and have privacy with dad. And same thing with mom. When the child's with mom, the child gets to enjoy time with mom and do things with mom and enjoy the privacy of the activities that they enjoy as well. But I want open communications just in general lines as far as where the child will be, how the child can be reached. And that's really the only thing that needs to be communicated. Of course, if she falls down and scrapes her knee or something, I would expect it. They would say, she tripped over, the curb or something, fell down, scraped her knee. She's fine. We put some hydrogen peroxide on, whatever, just, you don't even have to go into that detail, but I just expect co-parenting and sharing of information. You both love this child and you want what's best for her. You disagree on how to go about doing that, but there needs to be some seeming a lot of enmeshment. There needs to be a little bit less enmeshment, a little bit more autonomy with the child when she's with her respective parents. Is there anything further that we need for today?
Your Honor, as far as the drop-off time on Tuesday, per new schedule for kindergarten, the class begins at 7:45 in the morning. So and the drop-off time is 7:30. So we just wanted to see if we can do just a little bit earlier Tuesday morning so that Ms. Casella can get Mariella home and situated, ready to start school.
Mr.
And I
Freeman.
oppose that, Your Honor. We oppose it vehemently because mom has repeatedly told dad, you need to get her here so I can feed her and bathe her and do all these things. And dad says, she gets fed at my house. She's there 15 minutes early. It seems like a small thing, but if the court goes back and looks through the record of what's gone on here, there's so much more that I don't want to deluge the court with today. But
I get it. It's just inching and inching more and more and more and more. And I get it. I understand. Okay, so I'm going to deny that verbal request, Ms. Perret. at this time. You can raise it again, of course, at the time of the evidentiary hearing if you desire. Also, you don't think that there would be any benefit to being referred to FMC?
No.
No? Okay, very good. Then we'll avoid that then. Okay, so thank you for your time. I want to applaud the parties for your choice of counsel. They've both been very diligent, and I really appreciate the professionalism that's been demonstrated here. And I would like, I'll look forward to getting that proposed order. Please run it past Ms. Perret for her review and submit it to the court for the court's signature.
Your Honor,
I'll do that. Thank you, Your Honor.
Yes.
Your Honor.
I do apologize. Would you like the February 17th hearing vacated, or would you like it to remain on calendar?
I would like to continue it on calendar. I kind of foresee that as just to make sure that we've got that report in. Do you think that we need to have a hearing at that time, counsel, or do you want me? I just want to make sure that the report gets in, and then you know what? Let's do this. Let's leave that on calendar for a hearing. If you want to go forward with the hearing after you've reviewed the report, we can go ahead and do that. We can have a hearing. We'll just leave it on there. But if for some reason you don't feel like there's a hearing that's necessary after you've received the report, you can just let the court know, just stipulate to vacate that hearing. Does that sound good?
Sounds
Yes,
great.
ma'am.
Very good. All right. Thank you so much. Y'all have a great day.
Thank you.
Thank you.
All right.
Thanks.
Good luck.
Thanks. Bye-bye.